Common words and phrases in legal Latin. Ad litem, for the suit or action. An adult must be appointed as a guardian ad litem to sign court documents for a minor. Alibi, elsewhere in another place. An affirmative defense to a criminal charge. Bona fide, in good faith, can be used to express honesty, sincerity, or legitimacy. Causa, or cause, used in reference to cause of action. Caveat, beware, used as a warning. Caveat emptor, let the buyer beware. A buyer who takes possession of an item as is accepts the item with all of its defects and cannot complain at a later time. Codex, a manuscript, parchment, or a code of laws. Consensus, agreement. Coram nobis, before us, a writ issued to correct an injury caused by a mistake made by the court. Corpus delicti, evidence that a crime was committed, sometimes used as the body, in other words, elements of the crime, although in a murder case no body need be found. Corpus juris, body of law, the collected laws of the state or country. De facto, in reality, often used as from fact to fact. De jure, sanctioned by law. De novo, anew. An appellate court may review the facts supporting a judgment by motion de novo. After an arbitration, the court may set a case for trial de novo. Ducis tecum, bring with you. Attorneys may issue and cause to be served a subpoena ducis tecum, notifying the person named to appear at a certain date and place and to bring specified documents or items. Ergo, therefore. Errata, plural from erratum, singular, errors or error. Court rules or procedural statements often allowed a party to correct clerical errors in a pleading by filing an errata. Et alia, or et al., and others. Etc., or its, and so on. Et nunc, et semper, from now on. Exempli gratia, or e.g., for example. Ex more, according to custom. Ex officio, by virtue of the office, used in reference to official acts or acts of a government officer. Ex parte, from one side only, used to identify a contact by a party with a judge, arbiter, or mediator without notifying the opponent. Ex post facto, from what is done afterward. An ex post facto law is one that's designed to be applied retroactively, making some prior act or conduct that was legal at the time illegal as of the date of the law's enactment, or the reverse. Such laws are unconstitutional. Habeas corpus. You may have the body. A writ of habeas corpus provides immediate relief from illegal imprisonment by having the prisoner, the body, taken out of custody and brought before the court to allow the court to decide whether or not law enforcement, corrections, or the prosecution has violated the incarcerated defendant's rights. Hic et nunc, here and now. Hoc loco, in this place. Ibidem or ibid, the same place, used in documents to refer to the citation just previously referenced. Id est, or i.e., that is. In absentia, in one's absence. Some jurisdictions allow for a trial of a defendant in absentia on the grounds that by choosing not to appear, the defendant concedes the issues. In camera, or in chambers, hearings on sensitive issues are often heard in camera. Usually the lawyers go to the judge's chambers and with or without a court reporter making a record, meet with the judge to discuss and resolve an issue. Some issues must be held in camera. Incipit, here begins. Indicia, signs or marks. In extenso, word for word. In extremis, at the point of death. In flagrante delicto, while the wrong is blazing, used to describe a wrong observed at the time it is committed. Infra, below. In limine, on the threshold. In loco parentis, in the place of the parent. In perpetuum, forever, From this root stemmed the real estate concept of rule of perpetuity, in re, regarding, in se, in itself, in situ, in its natural location, in statu quo, in the same state, inter alia, among other things, inter alios, among other persons, inter nos, between or among ourselves, inter pares, between or among equals, inter se, between or among themselves, inter vivos, between living persons, used in discussion of trusts and wills, in toto, entirely, intra vires, within the powers, ipse dixit, he himself has said it, used in reference to an unsupported assertion or allegation, ipso facto, by the very fact, lex loci, the law of the place, licit, it is allowed, lis pendens, a pending suit, loco citato, in the place cited, locum tenens, a substitute or deputy. Doctors sometimes work under locum tenens contract. This is a contract in which they agree to work as a doctor for a healthcare facility. Locus delicti, the scene of the crime. Locus in quo, the place in question. Loquitur, he or she speaks. Mala fide, in bad faith. Mala in se, bad in itself, used to describe certain crimes. Malo animo, with evil intent. Mandamus, we command. A petition might be for a writ of mandamus, mandate. Manu propria, by one's own hand. Mea culpa, I am to blame. Me judice, in my opinion. Modus operandi, manner of working, commonly used in police work and criminal law to describe the usual or customary manner in which a criminal carries out or commits a crime or crimes. Multum in parvo, much in little. Nolo contendere, I do not wish to contend. In criminal law, this means a plea of no contest, which is treated for sentencing purposes the same as a plea of guilty. Non obstante, notwithstanding, non sequitur, it does not follow, used to describe a conclusion not justified by the preceding facts. Obiter dictum, an incidental remark, a comment inserted in a published opinion. Onus probandi, the burden of proof. Pedente lite, while the suit is pending. Per annum, annually. Per capita, individually. Per contra, on the contrary. Per diem, daily. Per incuriam, through carelessness. Per interim, meanwhile. Per se, intrinsically. Per stripes, by the roots, by family, often used in wills or documents establishing trusts for descendant family members. Persona grata, acceptable person. Persona non grata, person unacceptable. Posse comitatus, a posse. Most states have a law allowing peace officers to deputize citizens by merely demanding their assistance in a police activity. Refusal to do so is often a crime. Post-mortem, an autopsy. Prima facie, at first sight. Pro bono publico or pro bono, for the public good. Pro forma, as a formality. Pro rata, in proportion. Pro tempore or pro tem, temporarily. Attorneys sometimes sit as judges pro tempore. Postscriptus or PS, a postscript. Punctatum, point for point. Query verum, seek the truth. Quasi, sort of, as if. Quid pro quo, this for that, used to describe something given in return for something. Quo jure, or quo jure, by what right? Quondam, former. Re, concerning or regarding, nature. Recto, right. Res ipsa loquitur, the fact speaks for themselves. Used in negligence suits offering the injury itself as proof of negligence. Respondit superior, the highest responsibility, a doctrine under which an employer or superior officer responsible for the actions of an employee or agent. Scripsit, he or she wrote it. Sequitur, it follows. Seriatim, in series. Sic, thus, in such a way, usually used to indicate a misspelling in an original source being quoted. Sin die, until an unspecified date. Sine dubio, without doubt. Sine loco et anno, without place and date. sine mora, without delay, sine prole, without children, sine qua non, an indispensable condition. Anything that's sine qua non is absolutely necessary. Sponte sua or sua sponte, for one's good. Current legal usage refers to jury instructions which should be given sua sponte, in other words, they're necessary for the proper decision of the jury. Stare decisis, let the decision stand, a doctrine by which the published decisions of an upper court is binding upon the courts beneath in its jurisdiction. Status, condition, or state. Status quo, the same state. Stet, let it stand. Sub judice, before the courts. Subpoena, under penalty. Used to describe a document requiring a person to appear at a certain place and time under penalty of arrest if he or she fails to appear and testify. Sub rosa, in strict confidence, secretly. In modern usage, describes a covert investigation or operation. Sufficit, it is sufficient. Sua tempore, at one's own time. Supra, above. Ultima ratio, the final argument. Ultra vires, beyond legal authority. Veritas, truth. Versus, against. Via, away. Vice versa, conversely. Vincit veritas, the truth wins out. Ad hominem, a Latin term that refers to a personal attack. Argument, a series of clear reasons that leads to a logical conclusion. Blatant illogic, a tactic that reaches a conclusion without making an attempt at logical reasoning. Cause, a reason behind an effect. Cheap tactic, a strategy that distorts the facts and or uses emotional appeal to manipulate. Effect, something that happens because of a cause. Emotional appeal, an argument that manipulates by distracting or overpowering the facts with emotion. Fair tactic, a strategy that presents the facts and a conclusion without manipulation. False associations, a tactic that attempts to make connections based on a series of events rather than on logic. Flattery, a tactic that tries to win you over with personal praise. Magical thinking, a tactic that appeals to fate or luck rather than to reason and facts. Non sequitur, a Latin term that means it does not follow. Personal identification, a tactic that tries to get you to make a decision because you project yourself into the other person's place. Post hoc ergo propter hoc, a Latin term that means after, therefore because of. Premise, a reason stated in an argument. Propaganda, an argument that motivates by promoting an agenda more than by presenting the facts. Ridicule, a tactic that attacks the person rather than relying on facts or reasoning. Slippery slope, a tactic that uses emotional appeal by warning you about an imagined danger that will definitely result from a certain choice. Strong argument, an argument which makes important points that are directly related to the conclusion drawn. Syllogism, a simple form of an argument made up of three reasons or premises, a major reason, a minor reason, and a conclusion. That is a major premise, a minor premise, and its conclusion. Topic sentence, a one-sentence summary that states the point of a paragraph. Weak argument, an argument that makes minor or irrelevant points that are unpersuasive and do not lead logically to a conclusion. Adversarial system, the system of justice practiced in this country, where opposing parties battle against each other in court trying to get a result that favors them. The judge acts as an independent magistrate, making sure each side is treated fairly. There's always a winning and a losing side in such a system. Allegation, accusation that the accusing party intends to prove in court. Amicus curiae literally means friend of the court, a person with strong views on the subject matter of a lawsuit, but not involved in it directly, may ask the court for permission to file a brief giving the views on the subject. Attorney-client privilege, the doctrine that by law most information a client tells his or attorney in connection with his or her representation cannot be disclosed by the attorney or any of the staff. Brief, a written statement submitted to a court for the purpose of persuading the judge of the corrections of one's position. A brief argues the facts of the case and the applicable laws, supported by citations of authority. in which are called points and authorities. Citation: the reference to the volume and pages of a legal authority, such as the published decisions of a certain court, that will allow the reader to look up a decision. Cite: to refer to legal authorities in support of an argument or proposition of law. Conflict of interest: when a legal professional representing a client has information about the other party involved in the client's case or has some kind of relationship with the other party. Defendant: the person a lawsuit is filed against. Depublished: a state Supreme Court decides after it has approved a lower court's decision for publication that a decision conflicts with previous decisions of the state Supreme Court or the Constitution. The decision may no longer be cited or relied upon by lawyers or courts. Diligence: steady, energetic, active attention and care to something. This is required of a lawyer representing a client. Disclosed, made public. Discretion: the power of a judge to act according to his or her judgment after reviewing the facts of a case and the law that applies. Dissolution: breaking up a marriage, corporation, or partnership. Due diligence: a term used in many of the laws relating to lawyers' duties, meaning the correct level of care and attention. It isn't well defined, but rather depends on the circumstances of each case. Ex post facto law: a law making a person criminally liable for an act that wasn't criminal at the time it was committed. Examine: to ask questions of a witness at trial. Executor: a person who has the duty to dispose of the property of an estate according to the provisions of the will. Fiduciary: a person entrusted with handling money or property for someone else. The fiduciary has a duty to act with honesty and loyalty when dealing in the other person's interests. Gamesmanship: when lawyers zealously represent their clients, step across the lines of truth, and start making misleading and false representations of authority to the court. Jurisprudence: a system of law or the accumulated body of court decisions in that system. Law clerks: law students who have not graduated, and recent law school graduates who have not yet been admitted to the state bar. Motion to dismiss: a motion that asks the court to dismiss the plaintiff's claim without further consideration. Motion: an application made to a court for the purpose of obtaining an order that something be done in favor of the applicant. Parallel cite: a citation to a court's decision that's printed in more than one reporter. Perjury: giving false testimony in a court or lying under oath. It is a crime, and it is also a crime for a lawyer to knowingly allow a client or witness to do so. Plaintiff: the person who files a lawsuit asking for damages, a money award. Probable cause: a reasonable basis for belief in something, or that something is reasonably more likely to have occurred than not. Probate: the process of having a will declared valid by a judge. The probate court will also often supervise the actions of the executor. Recoverable: capable of being recovered. For example, the winning party can be awarded money or items by the court. Restraining order: a court order to stay away from someone. Reversed: a court decision set aside by a court of appeals. Sanction: a penalty or other means of enforcement used as an incentive to obey the laws or rules and regulations, including imposing fines, seizing property, or suspending a license. Securities: stocks, bonds, and other means of investments. Spoliation of evidence: the alteration or destruction of evidence. Statute of limitations: a law prescribing the maximum period of time after the occurrence of an injury or a crime during which a civil or criminal action may be taken. Superseded: overruled by a law of a higher level of government, federal or state laws will almost always supersede or be given greater weight than a city ordinance. To waive: to voluntarily give up a right you know you have and could have enforced in court. United States Code: all the laws of the federal government organized by subject matter into sections and published in several volumes. at this point 50 volumes. Work product doctrine. The doctrine that any material produced by an attorney while preparing for trial, such as notes and memos, is not subject to discovery by the opposing side. Work product. Any material produced by an attorney while preparing for trial, such as notes and memos. Zeal, passionate interest, zealous, overeagerness, and ardent interest in pursuing something.
Welcome to Legal Terminology. This pronunciation tape has been designed to assist you in learning to pronounce common legal terms correctly and with confidence. To use this tape, listen to each term as the narrator pronounces it, then repeat the term out loud. Repeating the terms this way will help you remember how to pronounce them. For terms that you find particularly difficult, you should rewind the tape and repeat the exercise. Let's get started. Abuse of discretion. Abuse of discretion. Adjudicatory. Adjudicatory. Arbitrary and capricious. Arbitrary and capricious. De novo review. De novo review. Declaratory judgment. Declaratory judgment. Declaratory provision. Declaratory provision. Declaratory statute. Declaratory statute. Delegation of powers. Delegation of powers. Due process hearing. Due process hearing. Due process of law. Due process of law. Exhaustion of remedy. Exhaustion of remedy. Federal Register. Federal Register. Inspection laws. Inspection laws. Judicial review. Judicial review. License. License. Licensor. Licensor. Quasi-judicial. Quasi-judicial. Quasi-legislative. Quasi-legislative. Ripeness doctrine. Ripeness doctrine. Rule-making. Rule-making. Statute. Statute. Statutory benefits. Statutory benefits. Subpoena. Subpoena. Substantial evidence. Substantial evidence. Substantive due process. Substantive due process. Agency by estoppel. Agency by estoppel. Agency by ratification. Agency by ratification. Consignee. Consignee. consignment, consignment, consignment contract, consignment contract, consignor, consignor, del credere agent, del credere agent, estoppel, estoppel, implied authority, implied authority, imputed, imputed, imputed knowledge, imputed knowledge, imputed negligence, imputed negligence, power of attorney, power of attorney, principle, principle, respondeat superior, respondeat superior, third-party beneficiary, third-party beneficiary, undisclosed agency, undisclosed agency, undisclosed principal, undisclosed principal, universal agent, universal agent, vicarious liability, vicarious liability, bankruptcy, bankruptcy, bankruptcy code, bankruptcy code, bankruptcy courts, bankruptcy courts, bankruptcy estate, bankruptcy estate, bankruptcy judge, bankruptcy judge, bankruptcy proceedings, bankruptcy proceedings, bankruptcy trustee, bankruptcy trustee, composition with creditors, composition with creditors, creditor, creditor, creditor beneficiary, creditor beneficiary, creditors meeting, creditors meeting, debtee, debtee, debtor, debtor, debtor in possession, debtor in possession, discharge in bankruptcy, discharge in bankruptcy, exemptions, exemptions, fraudulent preference, fraudulent preference, garnishment, garnishment, homestead exemption, homestead exemption, involuntary bankruptcy, involuntary bankruptcy, lien, lien, liquidation, liquidation, moratorium, moratorium, non-dischargeable debt, non-dischargeable debt, petition in bankruptcy, petition in bankruptcy, petitioner, petitioner, petitioning creditor, petitioning creditor, preferential assignment, preferential assignment, preferential debts, preferential debts, preferential transfer, preferential transfer, priority, priority, trustee in bankruptcy, trustee in bankruptcy, voidable preference, voidable preference, voluntary bankruptcy, voluntary bankruptcy, acceptance, acceptance, acceptor, acceptor, accommodation loan, accommodation loan, accommodation paper, accommodation paper, alteration, alteration, attachment lien, attachment lien, bearer, bearer, bearer instrument, bearer instrument, chattel paper, chattel paper, collateral, collateral, creditor, creditor, debt, debt, forge, forge, garnishment, garnishment, holder for value, holder for value, holder in due course, holder in due course, holder in good faith, holder in good faith, endorse, endorse, endorsee, endorsee, endorsee in due course, endorsee in due course, endorsement, endorsement, endorser, endorser, lien creditor, lien creditor, liquidated debt, liquidated debt, merchant, merchant. Mortgage, mortgage. Negotiable, negotiable. Negotiable instrument, negotiable instrument. Negotiate, negotiate. Negotiation, negotiation. Non-negotiable, non-negotiable. Non-negotiable instrument, non-negotiable instrument. Presentment, presentment. Primary liability, primary liability. Promissory note, promissory note. Repossession, repossession. Secondary liability, secondary liability. Secured creditor, secured creditor. Secured transaction, secured transaction. Uniform Commercial Code, UCC. Uniform Commercial Code, UCC. Unsecured, unsecured. Amendment of Constitution, amendment of Constitution. American Civil Liberties Union, American Civil Liberties Union. Bicameral, bicameral. Bill of Rights, Bill of Rights. Commerce Clause, Commerce Clause. Constitution, Constitution. Constitutional, constitutional. Constitutional amendment, constitutional amendment. Constitutional convention, constitutional convention. Constitutional courts, constitutional courts. Constitutional law, constitutional law. Constitutional limitations, constitutional limitations. Constitutional questions, constitutional questions. Constitutional right, constitutional right. Due process clause, due process clause. Due process of law, due process of law. Enumerated powers, enumerated powers. Equal Protection Clause. Equal Protection Clause. Equal protection of the laws. Equal protection of the laws. Equal Rights Amendment. Equal Rights Amendment. Establishment Clause. Establishment Clause. Executive Branch. Executive Branch. Executive Privilege. Executive Privilege. Federalism. Federalism. Interstate Commerce. Interstate Commerce. Intrastate Commerce. Intrastate Commerce. Judicial Branch. Judicial Branch. Legislation. Legislation. Legislative Branch. Legislative Branch. Legislature. Legislature. Magna Carta. Magna Carta. Preemption. Preemption. Prior restraint. Prior restraint. Privileges and Immunities Clause. Privileges and Immunities Clause. Rational basis. Rational basis. Referendum. Referendum. Senate. Senate. Supremacy Clause. Supremacy Clause. Supreme Court. Supreme Court. Taxing power. Taxing power. Articles of Incorporation. Articles of Incorporation. Articles of Partnership. Articles of Partnership. Association. Association. Board of Directors. Board of Directors. Business Judgment Rule. Business Judgment Rule. Bylaws. Bylaws. C corporation. C corporation. Certificate of Incorporation. Certificate of Incorporation. Charitable corporation. Charitable corporation. Chief Executive Officer, CEO. Chief Executive Officer, CEO. corporate agents, corporate agents, corporate directors, corporate directors, corporate domicile, corporate domicile, corporate officers, corporate officers, corporate securities, corporate securities, de facto corporation, de facto corporation, de jure corporation, de jure corporation, derivative action, derivative action, dissolution of corporation, dissolution of corporation, dissolution of partnership, dissolution of partnership, dividend, dividend, fiduciary duty, fiduciary duty, incorporation, incorporation, incorporator, incorporator, liquidate, liquidate, merger of corporations, merger of corporations, non-profit corporation, non-profit corporation, outstanding stock, outstanding stock, over-the-counter market, OTC market, over-the-counter market, OTC market, par value, par value, partnership, partnership, partnership agreement, partnership agreement, partnership assets, partnership assets, partnership debts, partnership debts, piercing the corporate veil, piercing the corporate veil, prospectus, prospectus, proxy, proxy, quorum, quorum, S corporation, S corporation, Securities and Exchange Commission, SEC, Securities and Exchange Commission, SEC, shareholder, shareholder, sole proprietorship, sole proprietorship, stockbroker, stockbroker, stockholder, stockholder, stockholders meeting, stockholders meeting. Subsidiary corporation, subsidiary corporation. Ultra V-rays, ultra V-rays. This is the end of side 1. Fast forward the tape to the end and turn the tape over to begin side 2. Accessory, accessory. Octus reus, octus reus. Aiding and abetting, aiding and abetting. Alibi, alibi. Arraignment, arraignment. Assault and battery, assault and battery. Attempt, attempt. Bail, bail. Battery, battery. Bigamy, bigamy. Bribery, bribery. Burglary, burglary. Commutation of sentence, commutation of sentence. Criminal law, criminal law. Criminal offense, criminal offense. Criminal procedure, criminal procedure. Criminal prosecution, criminal prosecution. Criminal statute, criminal statute. Double jeopardy, double jeopardy. Embezzlement, embezzlement. Exclusionary rule, exclusionary rule. Extortion, extortion. Felony, felony. Felony murder rule, felony murder rule. Forgery, forgery. Indictment, indictment. Larceny, larceny. Malice, malice. Manslaughter, manslaughter. Mens rea, mens rea. Miranda rule, Miranda rule. Misdemeanor, misdemeanor. Model Penal Code, Model Penal Code. Nolo contendere, Nolo contendere. Parole, parole. Probable cause, probable cause. Probation, probation. Prosecutor, prosecutor. Scienter, scienter. Violation, violation. Voluntary manslaughter, voluntary manslaughter. Acceptance, acceptance. Accord and satisfaction, accord and satisfaction. Adhesion contract, adhesion contract. Anticipatory breach, anticipatory breach. Bilateral, bilateral. Bilateral contract, bilateral contract. Boilerplate language, boilerplate language. Disaffirm, disaffirm. Enforceable, enforceable. Entire output contract, entire output contract. Equity, equity. Executed contract, executed contract. Executory contract, executory contract. Express contract, express contract. Formal contract, formal contract. Implied contract, implied contract. Impracticability, impracticability. Incompetency, incompetency. Lapse, lapse. Liquidated damages, liquidated damages. Offeree, offeree. Offeror, offeror. Promisee, promisee. Promissor, promissor. Quasi-contract, quasi-contract. Ratify, ratify. Reformation, reformation. Repudiation, repudiation. Rescission, rescission. Restitution, restitution. Revocation of offer, revocation of offer. Statute of frauds. Statute of frauds. Third-party beneficiary contract. Third-party beneficiary contract. Unconscionable. Unconscionable. Undue influence. Undue influence. Unilateral contract. Unilateral contract. Unilateral mistake. Unilateral mistake. Unjust enrichment. Unjust enrichment. Voidable. Voidable. Voidable contract. Voidable contract. Acknowledgement. Acknowledgement. Adversary. Adversary. Adversary proceeding. Adversary proceeding. Adversary system. Adversary system. Affidavit. Affidavit. Affidavit of service. Affidavit of service. Affirmation. Affirmation. Affirmative defense. Affirmative defense. Allegation. Allegation. Amendment of pleading. Amendment of pleading. Amicus curiae. Amicus curiae. Appearance docket. Appearance docket. Change of venue. Change of venue. Claimant. Claimant. Class action. Class action. Concurrent jurisdiction. Concurrent jurisdiction. Counterclaim. Counterclaim. Court of equity. Court of equity. Court of general jurisdiction. Court of general jurisdiction. Court of limited jurisdiction. Court of limited jurisdiction. Cross action. Cross action. Cross claim. Cross claim. Cross complaint. Cross complaint. Deposition. Deposition. Discovery. Discovery. Diversity jurisdiction. Diversity jurisdiction. Diversity of citizenship. Diversity of citizenship. Equitable action. equitable action. In personam action. In personam action. In rem action. In rem action. Injunction. Injunction. Interplead. Interplead. Interpleader. Interpleader. Interrogatories. Interrogatories. Jurisdiction. Jurisdiction. Jurisdiction in personam. Jurisdiction in personam. Jurisdiction in rem. Jurisdiction in rem. Jurisdiction quasi in rem. Jurisdiction quasi in rem. Jurisprudence. Jurisprudence. Lis pendens. Lis pendens. Litigation. Litigation. Long arm statutes. Long arm statutes. Memorandum of law. Memorandum of law. Motion for summary judgment. Motion for summary judgment. Motion to dismiss. Motion to dismiss. Preponderance of the evidence. Preponderance of the evidence. Pre-trial. Pre-trial. Pre-trial conference. Pre-trial conference. Pre-trial motions. Pre-trial motions. Procedural law. Procedural law. Proceeding. Proceeding. Quasi in rem action. Quasi in rem action. Reply. Reply. Request for admission. Request for admission. Statutes of limitations. Statutes of limitations. Subject matter jurisdiction. Subject matter jurisdiction. Substantive law. Substantive law. Summons. Summons. Third-party complaint. Third-party complaint. Trial court. Trial court. Venue. Venue. Verification. Verification. verified, verified. Adjudication, adjudication. Admissible evidence, admissible evidence. Admission, admission. Affirm, affirm. Alternative dispute resolution, alternative dispute resolution. Alternative pleading, alternative pleading. Amicus curiae, amicus curiae. Appellant, appellant. Appellate court, appellate court. Appellate jurisdiction, appellate jurisdiction. Appellate review, appellate review. Appellee, appellee. Arbitration, arbitration. Bifurcated trial, bifurcated trial. Burden of proof, burden of proof. Certiorari, certiorari. Conciliation, conciliation. Court of Appeals, court of appeals. Court reports, court reports. Cross appeal, cross appeal. Dicta, dicta. Direct examination, direct examination. Directed verdict, directed verdict. Dismissal, dismissal. Exhibit, exhibit. Expert witness, expert witness. Hung jury, hung jury. Impanel, impanel. Impartial juror, impartial juror. Judgment notwithstanding the verdict, judgment notwithstanding the verdict. Judgment on the merits, judgment on the merits. Judgment on the pleadings, judgment on the pleadings. Juror, juror. Mediation, mediation. Mistrial, mistrial. Notice of appeal, notice of appeal. Out-of-court settlement. Out-of-court settlement. This is the end of Side 2. Please proceed to the next tape to continue.